Good evening, everyone. Good morning and good afternoon to some of you in UK and in Middle East. Welcome to this webinar, jointly co-hosted by Institute of Construction Claims Practitioners, in short ICCP, and the Hong Kong Institute of Construction Adjudicators. My name is Joseph Kwan, a fellow member of ICCP, Vice Chair of HKICAdj, and the moderator of this webinar this evening.
Good morning, everyone. I hope you are all doing well, or afternoon, evening, according to where in the world you are. As this is not an ICCP meeting, I will just take a very quick moment to briefly introduce who we are and what we do. So in full, we're the Institute of Construction Claims Practitioners, and we are a professional members organization that exists to recognize the skills, qualifications, and expertise that is needed for the professional management of construction claims. So our objectives are to establish international professional standards, to give recognition to those who have achieved those standards, and to help and educate those who would like to gain the necessary experience to become a claims practitioner. Okay, so I'll briefly just say we do have an elected president and steering committee that is elected from the fellowship. We have 3 levels of individual membership, which are based on experience and education and career criteria. We also have a student membership for undergraduate students, and they can then graduate into graduate membership. We have corporate membership for corporations with dedicated claims departments, or of course, claims businesses. And we also offer a variety of membership benefits, including a knowledge bank of research, white papers, articles, etc., practical templates, which members can use to ensure that their claims are of a high standard. We have a private LinkedIn group where members can ask and answer claims questions in a confidential setting. And of course, our members get certificates of membership and logos. And we do have regular CPD webinars, of which mostly are free to the public, but only members get a CPD certificate. Okay, and I know that that was very quick because this is not our event, but if you would like to know more, please have a look at our website, instituteccp.com, or contact me at jennifer.smith@instituteccp.com, and I would be happy to answer all of your questions. Okay. And with that, I will hand it back to you, Joseph. Thank you so much.
Okay, thank you, Jennifer. For our institution, there are 2 upcoming events. Our first adjudication conference will be held in September, as well as our 1-day and 4 days training to be scheduled later this year. The details of the 2 events, the 3 events, will be announced on our website in due course. So this evening, the topic is the engineers' responses and determinations. Many contentions exist on construction projects because the engineer fails to respond to claim within the contractual time frame, fails to certify amounts legitimately due for claims, and when rejecting claims or reducing the amount awarded, fails to adequately explain the reasons for doing so. In many cases, these actions will escalate to time-consuming and costly disputes for the employer. This CPD presentation will explain the actions that the FEDIC contract oblige the engineers to take when responding to claims, explains good practice when preparing responses, and outlines a procedures which is a which is fully in accordance with the contract, and if followed, will ensure that all engineers' responses will be accepted by both the contractor and the employer. It's our privilege to have our honorable speaker, Mr. Andy Hewitt. He has over 40 years experience in the construction industry, which has been gained in the United Kingdom, Africa, and the Middle East. He has held senior positions with contractors, subcontractors, and consultants, and has worked on several Ionic projects in the Middle East. He's the author of the following books: Construction Claims and Responses, Effective Writing and Presentations, The FedEx Forms of Contract, Obligations of the Parties, FedEx 1999 Notices, a guide to the requirements, content, and compositions of notices under the red, yellow, and silver books, and more other type of contractual books as well. And this experience in commercial contract and project management led him to specialize in contractual issues, claims, and dispute management, and is managing director of Hewitt Diversified Partnership. Andy also works as an educator and trainer, and to this end, he has developed and launched the Claim Class training courses, which are offered on an international basis through various of media and platforms. Andy, we would love to hear from you. Please, the stage is yours. Thank you.
Well, thank you very much, and thank you very much for putting together this joint presentation with the HKIC Adjudicators and ICCP. So welcome to all the ICCP members who already know Jen and I, and it's great to be speaking to a new institute or professional organization, and especially in Hong Kong. So without further ado, let me get the presentation up. So this webinar, as Joseph very comprehensively explained, is about engineers' responses and determinations. And whilst it uses the FIDIC forms of contract, which some of you will be familiar with, a lot of the principles that I'm going to talk about are transferable to different forms of contract. So let's have a start. Let me just close a few windows down so I can get the full presentation up, and we should be good to go. So firstly, let's have a few thoughts. I assume I'm speaking to some people who are quite experienced within the construction industry, and some of those people will be experienced in the management of claims. So let me just put a few thoughts to you and ask some rhetorical questions. So firstly, have you experienced a situation where the engineer does not respond to a claim within the contractual time frame? And I am guessing that most of you will say yes to that question. Have you experienced a situation when the engineer's response has done little to resolve the claim? So the contractor has submitted a claim, either a good claim or a bad claim, but the engineer has either not dealt with the claim correctly and made an award or a response which is really unfair or unreasonable, or has not acted proactively to finalize the claim. And if it is unfair and unreasonable, the claim is unfair and unreasonable, has not rejected it in a way that the contractor will accept that rejection. Have you experienced a situation where the engineer's response has caused the matter to be escalated to a dispute? So where the contractor's got a just claim, but the engineer tries to unjustly defend that claim and reject it or reduce it to an unfair amount. And the only way then that the contractor can get what he considers or his fair entitlement is to elevate it to a dispute, either adjudication or arbitration. Do you think that failures of the engineer to carry out their contractual obligations with respect to claims is helpful to projects? So we've got an engineer who is not carrying out his obligations, or is treating claims unfairly and unfairly rejecting claims or reducing the value of claims. Is that actually helpful? So there we go. That's a couple of things for you to think about through this course. So as we look at FIDIC, there are many clauses under FIDIC that give entitlement to either an extension of time or the payment of additional cost. And all of these in the FIDIC contracts contain the following note. After receiving the notice, the engineer shall proceed in accordance with subclause 3.5 determinations to agree or determine these matters. Now, the FIDIC says that if a certain type of event happens, the contractor should give notice of that event. What FIDIC is a little bit confusing about here is really a bit unclear how the engineer is expected to proceed to agree or determine these matters, because at this point we've only had a notice and we haven't actually received the contractor's claim, but there is an obligation to the engineer to resolve these matters. Let's have a look, and I'm going to skip between clauses here to try and present the engineer's obligations in a logical manner. So you'll find I'll be skipping from one clause to another. But let's start with clause 20.1, which is the clause that deals with claims, which says, within 42 days after receiving a claim, or any further particulars supporting a previous claim, or within such other period as may be proposed by the engineer and approved by the contractor. So there's some leeway here. The engineer shall, so this is an obligation, not something that the engineer can consider as a may do. It's a shall do. Shall respond with approval or with disapproval and detailed comments. He may also request any necessary further particulars, but shall nevertheless give his response on the principles of the claim within such time, i.e. 42 days. So let's break this down. The engineer is obliged to respond within 42 days of receipt of the claim. The response may be either acceptance in full, which sometimes happens. It could be rejection, which often happens, or, which I think is the most popular, or the most, let's say, the most frequent response, is probably acceptance in full, acceptance, but with a reduced quantum. So you've asked for 100 days extension of time. The engineers examine the matter and concludes that 80 days would be a fairer allocation for the extension of time. If the claim doesn't contain sufficient information for the engineer to reach a conclusion, he may request further particulars. Now, it's often the case in my experience that a contractor submits a claim, it's an inadequately expressed claim, so it doesn't really prove the matter to the engineer, but the engineer knows that A, the event happened, and B, there could be some entitlement contained within the contract, but there are weaknesses within the contractor's claim. Maybe the contractor has not properly explained why there is entitlement and why the contractual provisions apply to this particular event. Maybe a delay analysis, which has been submitted with the claim to calculate the number of days extension of time, is not being done well or correctly, or is confusing, or is not in accordance with good practice. Well, this allows the engineer to actually request further particulars and say, okay, Mr. Contractor, in principle, I sort of agree with this, but you need to give me a better delay analysis to justify the amount of time that you are claiming. If the engineer does request further particulars, the engineer, when asking for the further particulars, needs to respond on the principles of the claim, which is really what I've just said. Yes, in principle, the claim is a good one, but I need more information to 100% verify that, or to check the calculations on the costs or the time or whatever. If the engineer rejects the claim or reduces the quantum of the claim, the response shall contain detailed comments. So this propensity of engineers to issue a one-page letter rejecting the claim for no particular reasons is not going to wash. Detailed comments means that the engineer needs to explain exactly why the claim has been rejected, or the engineer considers that 80 days is a fairer allocation of the time rather than the 100 days that have been claimed for. Let's go back to clause 1.3 communications, which states approvals, certificates, consents and determinations shall not be unreasonably withheld or delayed. So again, this is underlining the provisions of subclause 20.1 to respond within the 42 days. Why does FIDIC and, in fact, other forms of contract place such importance on the response time when a claim's been submitted? Well, firstly, we need to establish a revised time for completion or not if we're going to reject the claim, if the claim is not a sustainable claim, because we all need, every project participant needs to know the time that we're aiming for the completion of the project. This is one of the major things we need to do in construction. It prevents the deduction of delay penalties or not. If the time is going to be exceeded, well, the employer cannot apply delay penalties if an extension of time has been awarded. It allows the contractor to be paid for costs which have been legitimately incurred that are correctly claimable, which will aid the contractor's cash flow, which is always got to be a good thing for a project. And it allows for the contractor to be paid for work carried out, which is the subject of a claim. So possibly the payment for a variation, which has been claimed rather than paid through the normal variation process. It assists project cash flow, we've already mentioned, and it reduces disputes. The longer we leave claims unresolved, unsettled, undealt with, let's say, the more and more we are pushing the matters to disputes. And you guys that deal with adjudication will realize that when the claims are left to the end of the project, either for submission or for responses, because we often get engineers that say, oh, I've got all these claims, but we'll leave them till the end of the project and then we'll negotiate. That is a typical scenario when the contractor is not going to be happy and is going to have to be obliged to raise disputes to get his claims dealt with and resolved to what he thinks is a reasonable level. The dealing with claims in a timely and fair manner promotes goodwill and cooperation between all the parties. I'm sorry, that was the end of the list. So let's have a look at what subclause 3.5 determinations says under FIDIC. Whenever these conditions provide that the engineer shall proceed in accordance with this subclause 3.5 to agree or determine any matter, which we've already discussed, many of the clauses do place this obligation on the engineer. The engineer shall consult with each party in an endeavour to reach agreement. If agreement is not achieved, the engineer shall make a fair determination in accordance with the contract, taking due regard of all relevant circumstances. The engineer shall give notice to both parties of each agreement or determination with supporting particulars. So let's break this down. Firstly, the engineer is obliged to consult with each party. So he needs to go and talk to the contractor and say, this is what I've received your claim. This is what my findings are, as I've issued in my response anyway. What do you think? And actually engage in discussions. The engineer is also obliged to discuss it with the employer. And it's not a case of seeking the employer's approval. It is, this is what I've done. in accordance with my contractual obligations. These are my findings. Do you have any questions, Mr. Employer? Personally, I like to consult with both parties together, get them in a room, and encourage discussion, a three-way discussion between myself as the engineer, the contractor, and the employer. And then we can bring out everybody's points of view, arguments, contentions, etc., and hopefully resolve them at this point. The engineer is obliged to endeavour to reach agreement. So he's in a bit of a, I would say, an adjudicator's role, but it's not quite that. But it's to encourage the parties to talk, to encourage the parties to question each other, and in fact the engineer's finding, so that we can hopefully make an agreement at this point. And sometimes it's not 100% agreement, but the contractor maybe say, well, okay, I've read your findings. I don't agree with them 100%, but you said 80 days. I'm asking for 100 days. The employer is maybe saying something else, but okay, I'll accept 90 degrees, just 90 days, for example, just to call it quits and to settle the matter now. The employer may say, well, I'm quite happy with that. Let's close the matter, make it 90 degrees, and let's move on. If we do reach this sort of agreement, the engineer then needs to formalise it, because he's obliged to give a notice to both parties with supporting particulars. So the notice should include detailed particulars of the contractor's asked for 100, I think it's 80, but during the agreement process, the employer and the contractor have agreed to settle at 90 days. The matter is finished, it's formalised, and we've all agreed to it. Where are we now? Hang on, why is my presentation thingy not working? There we go. If we don't reach agreement like this, and the contractor's still sticking out for his 80 days, and maybe the employer is saying, well, I don't think you're entitled to anything at all, the engineer is obliged to make a fair determination in accordance with the contract, taking due regard of all relevant circumstances. So he now needs to issue a detailed determination. He needs to be neutral in this, which we'll talk about in a while, and he needs to, this then becomes a formal determination, which means that this is what I think, guys. If you don't like it, you have to raise it to the next level and raise it as a dispute. Now, the way in which the determination is presented will either, if it's a good determination, convince both parties that the engineer is correct in his findings, and if they raise a dispute, they will fail, or if it's a badly written determination, will do very little to resolve the matters and will actually encourage one of the parties to raise a dispute. So in the case of a determination, the engineer is obliged to give notice to both parties with supporting particulars. Now, it's the supporting particulars that are important, as I alluded to previously. So clause 3.1, let's have a look at where the engineer should be under FIDIC and under other forms of contract when he is examining the contractor's claims. So subclause 3.1 states, whenever carrying out the duties specified in the contract, the engineer shall be deemed to act for the employer. Now, FIDIC recognises that the engineer is appointed by the employer to look after the employer's interests. We've got to remember that many employers are not sophisticated developers. They're not familiar with contracts. They are not familiar with the construction industry. They just want something building. So the engineer is appointed to look after the employer's interests. However, does this mean that the engineer is obliged to defend the employer's position by not making a fair determination in accordance with the contract, taking due regard of all relevant circumstances? Now, many engineers think it's their duty and their responsibility to reject the contractor's claim so that there's no extension to time issued, so that the employer can apply delay penalties, so that the employer doesn't have to pay additional money to the contractor. Now, this is not quite in accordance with a fair determination, in accordance with the contract, taking due regard of all the relevant circumstances. So FIDIC actually, sorry, let's go back. FIDIC actually changed for subclause 3.1 and obliged the engineer to act neutrally and make a fair determination. And in this case, many engineers will say, well, I'm not acting in the employer's interest. Well, you are acting in accordance with your obligations under the contract to act fairly when it comes to making determinations and reviewing claims. So what should be, we've talked about 3.5, and in fact subclause 20.1 requires the engineer to respond or to produce a formal determination. So what should be included in this response or determination? And it is not the 1 or 2 page letter to say, dear Mr. Contractor, in relation to your claim for additional time and costs, your claim is rejected because we are defending the employer's interests, or you didn't do this, or you didn't do that, or your delay analysis is rubbish. Okay, that's not going to resolve anything, is it? So let's look at the contractual requirements. Clause 20.1, the engineer must respond with approval or with disapproval and detailed comments. He may also request any necessary further particulars, but shall nevertheless give his response on the principles of the claim. So this is allowing the engineer to get as much information as he needs from the contractor through the claim, or possibly through additional particulars, and then go on and make a fair response. Under subclause 3.5, the engineer is obliged to make a fair determination in accordance with the contract, taking due regard of all relevant circumstances. So how can we achieve this? The engineer, therefore, has an implicit obligation to demonstrate to both the employer and the contractor that the response to the claim or the determination of the claim is fair and reasonable, and that either party chooses to raise the matter to a dispute, they will ultimately fail. So the engineer must, within these detailed comments, convince both parties that those comments and the engineer's findings are fair and reasonable. The engineer's response must therefore not be this 1 or 2 page letter. It needs to be a comprehensive document which sets out the findings clearly and in actual fact include the same criteria as a claim. So engineers out there that think it's a couple of hours job to respond to a claim are sadly mistaken. To respond to a claim so that it will not be elevated to a dispute is quite a long and complicated job. And we must ensure that the engineers team that are managing the project have got people within or available to respond to a claim. They've got the necessary qualifications and experience to respond to a claim correctly. Otherwise, we're on the road to disputes. So the response or determination needs to include, as a bare minimum, the following criteria: examination of the cause. What happened? Is the information included in the contractor's claim correct? And can we verify that it is correct? Examination of the effects, i.e. what happened, and linkage to the cause. So this happened on the project. The effect was it caused a delay to these activities. It caused the contractor to incur these additional costs, etc., etc. We must link the effect with the cause. Even if the claim doesn't do this, the engineer needs to establish that it actually does before an award can be made. We need to examine the final effect on the time of completion, which would generally be done by a delay analysis. We need to examine the contractor's delay analysis, such as it is, and either verify that it's done in accordance with correct principles and it's actually been accurately carried out. And if we have any differences, we need to explain why we consider 80 days is the correct calculation instead of the 100 days claimed, for example. If we are going to change the contractor's claim for costs to a lesser amount, we need to include calculations of why we disagree or the correct calculations for the additional costs if we disagree with the contractor's claim. We need to thoroughly examine contractual entitlement, principally to convince the employer that the contractor is entitled to something, if not the amount claimed, is entitled to an amount. And all of the above, just in the same way as a correctly presented claim, all of the above things should be substantiated, generally by use of the project records or through the contract. Over the years, I've developed, in acting in the capacity of the engineer or the engineer's person responsible for dealing with claims, I've developed a procedure for dealing with the engineer's response. And this is not a contractual thing, but it is in compliance with FIDIC's requirements and obligations for the engineer. So this is something I'd like to share with you. Firstly, on receipt of the claim, I would carry out an initial review, which would be a read through the claim and making notes of things that I don't fully understand, things that have not been explained too well, additional substantiation that I may need, any items which I'm confused about, and I will make notes of these. I then advise the claimant of any shortcomings of my concerns through the notes that I've made, or possibly I would raise formal queries and all of these things which are preventing me from reaching a final determination of the matter, so I can issue a response. Once I've got my questions answered or received any additional particulars, or in some cases, I have to say, the claim's so bad that I have to ask the contractor to revise the claim and deal with these matters: examination of cause and effect, a delay analysis, properly explained and substantiated cost calculations, etc. Once I've got all that information and I feel I can examine the matter in full, I'll then proceed with what I call an assessment. So this is my response as the engineer to the contractor's claim. I'll then prepare a detailed response document and issue it to the contractor and the employer, which sets out my findings. And whatever my findings are, either it's rejected because, it's accepted in full because, or I'm accepting it, but this is my calculation of the amount of extension of time or the amount of additional payment. And these will be issued to both parties. Once the parties have had a suitable time for review, and I will pressure them to do this because I'm wanting to deal with this, the matter, and get the matter resolved in a timely manner, I will meet both parties together and accept their comments. So, Mr. Contractor, you've got my response document. Do you agree with it? And then I will get the comments. Sometimes it's a case of, well, Mr. Engineer, you've not taken this into account, and my response will be, well, I've not taken it into account because it's not included in the claim. However, if you think it's pertinent, please give me your additional comments, additional particulars, and I will examine them and see if this changes my mind. Mr. Employer, what do you think? And we get the we get some interaction, we get things drawn out from both parties, and we can discuss them, hopefully in a professional manner, and hopefully pushing towards reaching agreement. Now, it's my obligation as the engineer to take into account any comments, however sometimes stupid they are, or whether they were included in the additional claim, or whether they are further additional comments or particulars. And I will, after the discussions or possibly the submission of further particulars, I will examine these and revise my response document where I consider it's appropriate. I will also, in that document, say, well, the contractor made this point, that point, the other. I've examined these points, but this does not change my opinion because. So we if you like, we are producing an audit trail, not only of the claim, but of the meeting to try to achieve agreement. And then I would issue my revised document, and we'd, after a suitable time to the review, we'd sit down and we'd meet again. I think the maximum time I've done this, I think it was, I went to revision D of my response document, because every meeting we had, either the employer or the contractor came up with further information which had not been discussed, but nevertheless, we had to follow the procedure, and we did eventually reach agreement. So we keep repeating this until we've reached an agreement. If, however, in the very, very few times that this procedure doesn't result in an agreement, we don't reach an agreement, I then need to proceed with that formal determination and issue a fully detailed determination document with a notice which sets out my findings. And that determination document will include details of all the meetings that we've had, the additional particulars, and it will say, this is my final opinion on the matter, this is my determination. And really what I'm doing is throwing the gauntlet down here as the engineer to both the contractor and the engineer and saying, this is what I consider is fair and reasonable under the contract. If you want to challenge that, you now have to raise it as a dispute and pass it on to the Hong Kong Institute of Construction Adjudicators for resolution. So that is the end of my fairly brief presentation. I hope you found it interesting. I hope you found it useful, and hopefully you'll take away one or two nuggets. And if you are dealing with claims from the point of view of the engineer, you may be able to improve how you do this, having listened to this. So time for any questions or any discussions. If you, I don't like just a Q&A session, but if you've got any points that you'd like to make, share your experiences with the rest of us, that's always beneficial. So thank you for listening.
Thank you, Andy. I'll just jump straight in. I have received a question and I have sent it to you if you would like to read it as I read it out. It says, in regard to the extension of time, A, is it necessary for the engineer to determine the EOT prior to the date of completion? B, if the EOT is not granted within the currency of the contract, does it render the time at large and enforcement of liquidated damages as redundant? This is a very long question. I will break it back up into parts. Why don't we actually just stop there and consider A first? Is it necessary for the engineer to determine the EOT prior to the date of completion?
If we are talking FIDIC, absolutely it is. The engineer must determine and respond to the claim within 42 days. Now, if you're on a 2-year project and the claim was submitted in month 3, we can't wait until month 24 to see what happens. Other forms of contract will require the claim to be submitted and the claim to be responded to within similar timeframes. So yes, we can predict the effect of the delay on the time for completion, and therefore we should award an extension of time. So even if it's not in a specific provision of the particular contract, it is good practice to deal with claims immediately and not to wait and see what happens.
Okay, part B of that question. If the extension of time is not granted within the currency of the contract, does it render the time at large and enforcement of liquidated damages as redundant?
This would depend very much on the legal jurisdiction, but in principle, yes. Again, the engineer is not either complying with his obligations, which is a breach of contract on the employer's part, or is not acting under with good practice by deferring the issue of extensions of time. We need an extension of time as soon as possible to establish a new date for completion, or alternatives. If the claim is rejected for good reasons, so the contractor knows that he's still got to meet the original date for completion. Thanks, Jen. By the way, I'm not actually seeing the written version, so I am relying on you repeating them.
Oh, okay. If you click on the chat, I've sent you a message. Part C was, what will be the relevance and validity of the extension of time if the engineer does not assign any reason for the granting of an extension of time? And what happens to the prolongation costs?
Well, the first thing is, if I've understood the question correctly, sorry, just repeat the first part, Jen, please.
Okay. What will be the relevance and validity of the extension of time if the engineer does not assign any reason for granting an extension of time?
Okay. If the engineer doesn't give any reasons, doesn't give the detailed particulars that I've been talking about, well, if either party disagrees with it, they've got no means of seeing the engineer's reasons for either rejection, reduction, or award in full. So without giving reasons, either party is likely to disagree with it. We've always, well, I guess many of us are parents. When you are teaching your kids or you're telling your kids to do something, it's not just a case of don't do that. It's don't do that because if you do it, you might fall off and hurt yourself. We've got to give reasons for things. It's otherwise the kid doesn't know why you shouldn't do it.
Okay, thank you. And the final part of that question, what happens to the prolongation costs?
The prolongation costs are associated with the extensions of time. Generally, under most forms of contract, if you have an extension of time, you will be able to claim prolongation costs. If you're not awarded the time, or you don't agree with the amount of time that you're awarded, the prolongation costs will change accordingly. So just to clarify, contractor applies for 100 days extension of time with associated prolongation costs for 100 days. The engineer either determines or we agree to 80 days, and the contractor's happy with that. The extension of time is awarded for 80 days, so the prolongation costs need to be recalculated for 80 days instead of 100 days.
Okay, thank you. All right, the next question, I hope I am asking this correctly. To whoever posed this question, if I have mistranslated it, please repost the question. Do you have any good suggestions to handle the quantum of claims accumulated during the progress of works? So I think what the person meant was the quantum of claims have accumulated during the progress of works. And do you have any suggestions of how to handle that?
Well, yes, from the contractor's point of view, get your claims in quickly, in a timely manner, comply with the contractual timeframes. From an engineer's point of view, exactly the same. Perform your obligations and perform them within the contractual timeframes. So deal with claims as and when they occur through the life of the project, rather than leaving them all to the end. Many contractors think that we need to submit a claim because we're running out of time. No, it's the wrong way of looking at it. We need to submit a claim because we are entitled to submit a claim. So if you think about it in the second scenario, an event happens, it's going to delay the project, submit your claim, get it dealt with. If you wait until the end of the project and you are running out of time and you suddenly realize that you're not going to finish by the completion date, and you then start thinking, how can we get an extension of time? That's totally the wrong way of looking at it.
Okay,
sorry, Jen.
Thank you.
Answer the question. I hope so, yeah.
I think the answer is always get your claims in on time.
Yeah, and respond to them.
Yes. All right. Next question. Can you please advise what action can be taken with FDIC where there is no dispute between the contractor and the employer, but the engineer, a FDIC member engaged and funded by a third party on behalf of the employer, has acted with apparent but unrequested partiality, but whose actions are leading the employer toward needless expense and probable arbitration?
I don't understand that. If the employer and the contractor have agreed to something between them, even if the engineer doesn't agree with that, let's say that the employer is happy to pay the contractor or an award an extension of time of this, and the employer and the contractor agree to that, but the engineer thinks that the employer is maybe paying too much. Well, the engineer is doing his job, is advising the employer. My professional opinion is that you only need to pay this amount. But if the employer wants to pay more for his own reasons, we've got to remember that the contract is between the contractor and the employer, and those two parties can agree whatever they wish. It's an unusual situation, but sometimes we get employers and contractors that have got good relationships. You know, they've worked on many projects, and the employer's very happy with the contractor. The contractor's happy with the employer because he's always treated fairly. So, you know, the employer might say, well, this contractor's a great guy, he's always helpful. I'm quite happy to pay him possibly more than the engineer thinks I need to. It is an unusual situation. I think within the question was, would this lead to arbitration? Well, no, it wouldn't, because the contractor and the employer have agreed. And obviously they've taken the engineer's comments into account, but they've still agreed to do something else. And if they've agreed, that's all we need. There is no dispute. All
right. Yeah, I guess don't borrow troubles if everybody's in agreement.
Yeah, exactly.
Yeah, I did notice that, and please apologize for my pronunciation, Biangire Paul Rusoke. I think if you can parse out the actual pronunciation of your name, you did have your hand up. If you would like to ask a live question, please raise your hand again, and I can unmute you. I don't see another question, so while people are furiously typing, I will just announce a few upcoming events, if I may. For later this week, on the 9th of June, we will have a webinar, Proving and Pricing Termination Claims. And if you would like to register for that, go to our LinkedIn page, and then you can find the registration details. We have not yet opened registration, but on the 20th of July, we will have a webinar on the common pitfalls arising from careless construction services procurement. And that will be like a case law webinar. And we will have a half-day conference on the 20th of September. And yeah, we are going to be having a lot of information coming up on LinkedIn about that. And that will be free to members and $50 to non-members. But until the 14th of July, we will have an early bird special. And we have quite a roster of big names in construction claims who will be presenting and discussing their areas of expertise. All right, Joseph, do we have any more questions?
Let me check. We don't have any more, but one of your participants raised his hands.
Yes, and rather than butcher his name again, I will unmute you and you may please say your name yourself so it's correct. And I have allowed you to speak.
Okay, thank you, Jen. It is Paul. It was correct, Paul Biangire Rusoke. Yes. So my question to Andy, it was in the chat box. He gave the procedure of meeting the parties raising issues and then the response, and then the draft response for them to comment. So that my question was that, is that all done within the 45 days required in the contract, or that is the 45 days in the contract start to count after those consultations with the different parties in the contract? Thank you.
Hi, Paul. Always nice to speak to you. Paul's an ICCP member, a regional representative, and has been through quite a few of our claims class courses. So, Paul, great to hear from you, and thanks for a good question. No, the 42 days mentioned in FIDIC is for the engineer to respond. That response could be your claim's rejected. Your claim is, or my findings are that your claim is approved, but with a reduced quantum, or your claim is approved. Or I don't quite understand all the information. Your claim is, let's say, not very good. I need some additional particulars before I can finalize my response. So that's the 42 days. Either give a response or ask for further particulars. And once you've got the further particulars, you've got the further 42 days. Now, from that point, when the engineers issued a response, that's when the procedure to attempt to reach agreement or to issue a determination if we can't reach agreement kicks in. Now, there is no time frame set in 1999 editions of FIDIC for that second part of the procedure, attempt to reach agreement or issue a determination to take place. But good practice says it should be as soon as possible. And in fact, in 2017, the FIDIC have introduced timeframes for that second part. So FIDIC are really stressing in the latest versions of the contract that these claims need to be dealt with within timeframes. And we can't leave them until the end of the project. So thanks for bringing that up. It's a very good point. Okay,
thank you. All right. The next question is also from an ICCP member. This is from Bashir. And the question begins with a situation that he had, and then the question will follow. So the situation he encountered in Qatar was a case where a subcontractor filed their extension of time claim directly with the court, bypassing the contract procedure after the completion of the works. And surprisingly, the courts admitted their claim despite the condition precedent specified in the contract. So the question is, given this scenario, he is curious to know your thoughts on how local jurisdictions can sometimes overlook or bypass the condition precedent clauses in contracts.
Okay, well, firstly, I must say that I'm not a lawyer. This is more of a case for the law rather than contractual matters. But having lived and worked in the Middle East for many, many years, nothing surprises me. In other jurisdictions, the courts would not even entertain the case and say, Mr. Subcontractor, go back and follow the obligations of your contract, submit a claim, and then if it is not agreed, you can submit it to adjudication. And then if you still disagree with the adjudication, then you can bring it to court. We've got to look at the law, and it seems a bit ridiculous to me that the subcontractor would even think about doing that if he's not followed the procedures in the contract. But hey ho, nothing surprises me that happens in the Middle East.
So he did have a follow-up question. Have you come across similar situations or challenges yourself?
I have not. That's why I said it was an unusual case. No, I haven't.
Okay, but do you have any tips on how such instances can impact the overall contractual process and fairness? Like, do you have any sort of thoughts on that?
Well, my thoughts are really the contract is there for a good reason, and most of the, let's say, standard forms of contract, the ones that have been in use for many, many years, such as FIDIC, such as the JCT in the UK, or the NEC, or the ICE, and I'm sure in Hong Kong you've got your own forms of contract, probably based on the British systems. You know, they've been developed for a reason. They're not only legal documents, but, you know, they are written by engineers for engineers, and they include sensible procedures that work in the construction industry. So I think we must follow the guidance of the contract. And if we can't get a resolution after following that guidance and performing our obligations, then it's a matter for you guys in Hong Kong, maybe adjudication, and if that doesn't work, maybe for the courts. But there are procedures, and if we do things properly, let me just take a minute here to extol the virtues of the Institute of Construction Claims Practitioners. Our values are to manage and deal with claims, either submitting claims or responding to claims, in a professional manner, because we see so many times that claims are prepared inadequately, which lead to disputes. Responses are dealt with inadequately, which also lead to disputes. And the reason for this is because either the contractor or the engineer don't have adequately qualified and experienced persons dealing with the matters. So it's a recipe for disaster in the first place. When it comes to construction, we all have highly qualified engineers, construction managers, etc., etc. When it comes to safety, we have safety officers that are qualified. When it comes to claims, we'll give it to the quantity surveyor to do. The project manager's got to deal with it in between all the other jobs that they've got to do. The engineer, well, we don't have a claims specialist, so we'll give it to this guy to deal with, who doesn't have any experience, background, or qualifications. And that is a big reason why claims become disputes, because they are dealt with by people without the correct knowledge to deal with them correctly. And this is one of the reasons why the ICCP exists, to educate people. And if anybody listening is dealing with claims on a regular basis, and you are not members of the ICCP, please take a look at what we do. Visit our website, have a look at what we do, because we will definitely be able to help you if you become a member. So, commercial break over.
Okay, thank you. I did see that there was a message, but then it disappeared. So I don't have any more questions for you. Maybe Joseph, if Joseph knows that there's a question.
Okay, no more questions from my side. Okay. Yeah, so shall we call that's the end of the presentation for today. Thanks very much, Andy, for the informative presentations, to walking us through the risk in relation to the engineer's responses and determinations under the FIDIC form of contract. And thanks very much for all the participants. And thanks very much for your time to join this webinar from Andy and Jennifer as well. Have a good evening, and we'll see you again next time. Stay tuned.
All right. Yeah, thank you so much for inviting us, Joseph.
You're welcome. You're welcome. We'll do this again in the near future, don't worry.
It sounds good. Thanks for inviting us. It's been a great joint presentation between the two institutions. This is what we should be doing, working together to help people. So thank you.
Thanks very much. Thank you, Jenny. See you next time. See you. Take care.
Bye.
Bye.
Thank you, everyone.
Bye.
Bye.
Thank you.
Bye.